7. Judicial empiricism. When Tom Sawyer and Huck Finn had determined to rescue Jim by digging under the cabin where he was confined, it seemed to the uninformed lay mind of Huck Finn that some old picks the boys had found were the proper implements to use. But Tom knew better. From reading he knew what was the right course in such cases, and he called for case knives. "It doesn't make no difference," said Tom. "How foolish it is. It's the right way and it's the regular way. And there ain't no other way that I ever heard of, and I've read all the books that gives any information about these things. They always dig out with a case knife." So in deference to the books and to the proprieties the boys set to work with case knives. But after they had dug till nearly midnight and they were tired and their hands were blistered and they had made little progress, a light came to Tom's legal mind. He dropped his knife and, turning to Huck, said firmly, "Gimme a case knife." Let Huck tell the rest. He had his own by him, but I handed him mine. He flung it down and says, "Gimme a case knife." I didn't know just what to do, but then I thought. I scratched around amongst the old tools and got a pickaxe and give it to him, and he took it and went to work and never said a word. He was always just that particular, full of principle. Tom Sawyer had made over again one of the earliest discoveries of the law. When legislation or tradition prescribed case knives for tasks for which pickaxes were better adapted, it seemed better to our forefathers, after a little vain effort with case knives, to adhere to principle but use the pickaxe. They granted that law ought not to change. Changes in law were full of danger. But, on the other hand, it was highly inconvenient to use case knives. And so the law has always managed to get a pickaxe in its hands, though it steadfastly demanded a case knife and to wield it in the virtuous belief that it was using the approved instrument. It is worthwhile to recall some of the commonplaces of legal history by way of illustration. One of the first difficulties encountered by archaic legal systems, founded upon the family and postulating for every sort of legal, social and religious institution the continuity of the household, was the failure of issue, the want of the son to perpetuate the household worship whom religious and legal dogmas required. No one thought of superseding these dogmas, but their manifest inconvenience and injustice were avoided by the device of adoption. Presently a better way of disposing of property after death without infringing upon ancient doctrines occurred to some Roman. Why not sell his whole household and estate to the person upon whom he desired it to devolve? If he so sold it and the purchaser was an honorable man, he would carry out oral instructions given at the time of the transfer as to the purpose for which it was made and the disposition to be made of the property. After this had gone on until everyone had begun to employ the preceding, a law of the 12 tables gave legal efficacy to the oral instructions, when the form of sale was had and wills had come into being. A better example is to be seen in the Roman law of marriage. The religious marriage, which was the only one recognized by religion and hence by law, was not open to the plebeian. In consequence he did not have his wife in manus or his children in pastors, and his household had no standing before the law. The law was not altered. It was not enacted that there might be marriage without a wife in manus and a family without children in pastors, but purchase or adverse possession and the statute of limitations were resorted to in order to bring the plebeian's wife into manus in another way. Our own law furnishes many such instances. When the Anglo-Saxon king desired to extend the protection of his peace to someone, he took him by the hand publicly and made of him, for legal purposes, a minister or servant, entitled to the king's peace which attached to members of his household. When wager of law, a simple oath backed by the oaths of one's neighbors that this oath was clean and unperjured, made the action of debt a worthless action upon simple contracts. Wager of law was not abolished, but the courts found a trespass and a breach of the king's peace in failure to perform a promise. If only something had been given presently in exchange for it, and thus imposed on our law of contract what has now become the formality of consideration. When the delay and formalism of real actions and the incident of trial by battle made them inadequate remedies, a fictitious lease and fictitious ejectment were resorted to in order to make another remedy meet the situation. When the hard and fast form of written declaration failed to provide for new cases of conversion of a plaintiff's property, the form was not altered but a loss and finding were assumed from the conversion. So that we are able to read in an American report of yesterday that the plaintiff casually lost 100 freight cars and the defendant casually found them and converted them to its own use. as if it were a watch or a pocketbook that had been lost. Newer and less crude modes of growth were long ago discovered by the law. But this primitive mode of growth by the employment of fictions, which is closely akin to the let's play so-and-so of our childhood, has not disappeared from political institutions. The turning back of the legislative clock is a familiar institution, and in at least one American state, where in an age of printing the Constitution requires every bill to be read in extenso 3 times before each house, it is possible to date to see 5 reading clerks simultaneously reading 5 separate bills, while the legislators peruse their morning papers and answer the letters of their constituents. After the general employment of fictions has accustomed men to intentional change of law, bolder devices come into use. Particular fictions, employed to meet a particular case or to change a particular rule, such as those referred to above, are superseded by what may be called general fictions, fictions having a more sweeping operation to alter or create whole departments of the law, introducing new principles or new methods rather than mere isolated rules. These general fictions are interpretation, equity and natural law. Interpretation as an agency of growth has to do chiefly with the legislative element. In primitive times, when the law is taken to be God-given and unchangeable, the most that may be permitted to human magistrates is to interpret the sacred text. Later, when the customary law has been formulated authoritatively, the antipathy of the stage of strict law to change and the desire to limit the judicial function to the purely mechanical in order to ensure uniformity leads to an endeavor to confine lawmaking to interpretation and logical development of the text. In the maturity of law, the dogma of separation of powers, whereby the making and the application of law are required to be wholly divorced so that judges are to do no more than ascertain the actual intent of the legislator according to settled canons of genuine interpretation, led countries governed by codes to attempt once more to make of the court a mere automaton. As a critic has put it, the theory of the codes in continental Europe in the last century made of the court a sort of judicial slot machine. The necessary machinery had been provided in advance by legislation or by received legal principles, and one had but to put in the facts above and take out the decision below. True, this critic says, the facts do not always fit the machinery, and hence we may have to thump and joggle the machinery a bit in order to get anything out. But even in extreme cases of this departure from the purely automatic, the decision is attributed, not at all to the thumping and joggling process, but solely to the machine. Such a conception of the process of judicial decision cannot stand the critical scrutiny to which all legal and political institutions are now subjected. Men insist upon knowing where the pre-existing rule was to be found before the judges discovered and applied it, in what form it existed, and how and whence it derived its form and obtained its authority. And when as a result of such inquiries, the rule seems to have sprung full-fledged from the judicial head, the assumption that the judicial function is one of interpretation and application only leads to the conclusion that the courts are exercising a usurped authority. The true conclusion is, rather, that our political theory of the nature of the judicial function is unsound. It was never truly the common law theory. In its origin it is a fiction, born in periods of absolute and unchangeable law. If all legal rules are contained in a mutable form in Holy Writ or in 12 tables or in a code or in a received corpus juris or in a custom of the realm whose principles are authoritatively evidenced, not only must new situations be met by deduction and analogical extension under the guise of interpretation, but the inevitable changes to which all law is subject must be hidden under the same guise. Beginning in this way, the mechanical conception of the judicial office was taken over in political theory through the adoption of the Byzantine idea of sovereignty and consequent reception of the Byzantine notion that the sovereign will both made and interpreted law, and was fixed therein by the general adoption of Montesquieu's theory of the separation of powers. Today, when all recognize, nay insist, that legal systems do and must grow, that legal principles are not absolute, but are relative to time and place, and that juridical idealism may go no further than the ideals of an epoch, the fiction should be discarded. A process of judicial lawmaking has always gone on and still goes on in all systems of law, no matter how completely in their juristic theory they limit the function of adjudication to the purely mechanical. In their origin, equity and natural law are also general fictions along with interpretation. In our law, the chancellor purported to be governed by a body of moral rules of superior sanctity to those of the strict law and to constrain men to perform the moral duties which those rules of equity and good conscience dictated. In the Roman law, the jurisconsult held himself bound to take note of certain principles of reason to be found in nature itself, by which all matters which he was free to pass upon should be tried, and to which all rules which were plastic should be shaped. In each case the result was an infusion of morals into law and a making over of the law, although in theory the old rules stood unaltered. These general fictions, which bore the brunt in past eras of growth, were wholly unsuited to the maturity of law, wherein stability is held the one thing needful, and so fell out of use. Interpretation is the general fiction of the 19th century. Law grows subconsciously at first, afterwards it grows more or less consciously, but as it were surreptitiously under the cloak of fictions. Next it grows consciously but shamefacedly through general fictions. Finally it may grow consciously, deliberately and avowedly through juristic science and legislation tested by judicial empiricism. It is not the least of the achievements of the common law that it discovered and worked out a system of legal development by judicial empiricism at a time when the rest of the world was running to Rome and was seeking to administer justice to modern Europe not by the free judicial methods of the classical jurists but by the hard and fast legislative text and fettered judge of Constantine and Justinian. A developed legal system is made up of two elements, a traditional or habitual element and an enacted or imperative element. The latter is usually the modern element and at present, so far as the form of the law is concerned, is tending to become predominant. The former is the older or historical element upon which juristic development proceeds by analogy. It is by no means universally true, however, that the imperative element in a legal system is the modern element and the traditional element speaks only from the past. In truth the two act upon and correct each other so that when either, from occupying the field too long, becomes too fixed and rigid, the needed flexibility is restored to the law by its rival. Yet on the whole, the traditional element is by far the more important. In the first instance we must rely upon it to meet all new problems, for the legislator acts only after they attract attention. And even after the legislator has acted it is seldom if ever that his foresight extends to all the details of his problem, or that he is able to do more than provide a broad if not crude outline. Hence even in the field of the enacted law the traditional element of the legal system plays a chief part. We must rely upon it to fill the gaps in legislation, to develop the principles introduced by legislation, and to interpret them. Let us not forget that so-called interpretation is not merely ascertainment of the legislative intent. If it were, it would be the easiest instead of the most difficult of judicial tasks. Where the legislature has had an intent and has sought to express it, there is seldom a question of interpretation. The difficulties arise in the myriad cases in respect to which the lawmaker had no intention because he had never thought of them. Indeed, perhaps he could never have thought of them. Here, if we insist on the dogmatic separation of powers, the courts, willing or unwilling, must to some extent make the law under the guise of interpretation, and our security that it will be made as law and not as arbitrary will lies in the judicial and juristic tradition from which the materials of judicial lawmaking are derived. Accordingly the traditional element of the legal system is and must be used, even in an age of copious legislation, to supplement, round out and develop the enacted element. And in the end it usually swallows up the latter and incorporates the results in the body of tradition. Moreover, a large field is always unappropriated by enactment, and here the traditional element is supreme. Juristic science works with the materials of the traditional element. It analyzes them and systemizes them, it traces their history, it seeks their philosophical foundations, it compares them with the traditional materials of other legal systems. In this way it prunes away arbitrary rules, molds doctrines into accord with reason and reconciles inconsistencies. In the future, under the influence of the sociological school in jurisprudence, it will add to the foregoing tasks study of the social operation of rules and doctrines and of the effects which they produce in action, in order to determine how far they achieve the ends of law. Legislation, on the other hand, except as it merely gives form to what has been worked out by juristic science and stamped with approval by judicial empiricism, has for its function to introduce new premises. In the past, under the influence of absolute ideas of law as something eternal and unchangeable, it took a jural revolution through reversion to justice without law and recourse to some such general fiction as that of equity or natural law to introduce new premises on any considerable scale. Today, no such jural revolutions are required. We have come to believe in conscious law-making, perhaps, indeed, to have too much faith in what may be achieved thereby. But the true function of codes, as jurists recognize today, is not merely to put the results of past legal development in better and more authoritative form, but even more to afford a basis for a juristic and judicial new start. Thus the jurist works over the traditional materials and the legislator provides new materials. From these the judge makes the actual law by a process of trying the principles and rules and standards in concrete cases, observing their practical operation and gradually discovering by experience of many causes how to apply them so as to administer justice by means of them. Such has been the common law from the first, such is coming to be the accepted theory of the rest of the world as failure of the 18th century attempt to make the courts mere automata leads the jurists of continental Europe to reject the Byzantine notion of the relation of the judge to the legislator and return to the more liberal doctrine of the classical Roman law. It was not always the Roman doctrine that law was made only by a legislative act or authentic interpretation by the sovereign. On the contrary, in Cicero's time precedents were enumerated among the forms of the law. At the end of the 2nd century a jurist could lay down, on the authority of a rescript, that the authority of cases adjudged to the same effect had the force of law. But Roman case law was made by jurisconsults rather than by judges, for whereas we entrust judicial power to a permanent judge learned in the law but bid him take the facts from a lay jury, the classical Roman polity put the judicial power in the hands of a lay index chosen for the case in hand and bade him take his law from a duly licensed jurisconsult. Where jurisconsults differed he had to decide what opinion he would adopt. Yet his decision, as that of a layman acting only for the one case, had no particular weight and was not preserved. What was significant was the answer of the learned jurisconsult whose opinion had been sought. And the most enduring part of the Roman law was made up of such opinions. As a permanent judicial magistracy grew up under the empire, the function of the jurisconsult waned, and it is not unlikely that judicial decisions would have established themselves as a form of law had not the union of all powers, legislative, administrative and judicial in the emperors after Diocletian led to the doctrine which Justinian handed down to the modern world with the authoritative stamp of his compilation, the doctrine that the judge can do no more than decide the particular case for the purposes of that case, and that only the sovereign by a legislative act is competent to make a binding rule which shall govern in other cases than that in which it was used as the ground of a decision. In the Middle Ages it was enough that this doctrine had behind it the unassailable authority of Justinian. But when Roman law was first applied by lay judges advised as to the law by learned doctors of the law from the universities, a practice which the trial in Shakespeare's Merchant of Venice may serve to illustrate, it was not to be expected in any event that the decisions of such magistrates could acquire the force of law. The doctrinal writer who furnished the materials for decision was the real voice of the law. Thus a conception of the judicial office arose on the continent which persisted after permanent courts learned in the law had been set up, since it appeared to accord with the theory of the separation of powers and was in line with the political theory which developed in the 17th and 18th centuries. It was in line also with the 18th century doctrine of a complete code deduced from the principles of natural law. Through the influence of the latter doctrine it became a favorite notion of legislators that the finding of law for the purposes of judicial decision might be reduced to a simple matter of genuine interpretation, that a body of enacted rules might be made so complete and so perfect that the judge would have only to select the one made in advance for the case in hand, find what the lawgiver intended thereby through application of fixed canons of genuine interpretation and proceed to apply it. The Code of Frederick the Great was drawn up on this theory. The intention was that all contingencies should be provided for with such careful minuteness that no possible doubt could arise at any future time. The judges were not to have any discretion as regards interpretation but were to consult a royal commission as to any doubtful points and to be absolutely bound by its answer. This stereotyping of the law, says Schuster, was in accordance with the doctrines of the law of nature, according to which a perfect system might be imagined, for which no changes would ever become necessary, and which could, therefore, be laid down once for all, so as to be available for any possible combination of circumstances. So firm a grip has this 18th-century doctrine upon American political theory that in 1912 a senator of the United States could tell us complacently that the uncertainties to which judicial construction of the antitrust laws had led us might be relieved through a bill he had drawn which, he said, enumerates in plain English every known practice and expedient through which combinations have stifled competition and prohibits anyone from engaging in them. In the same spirit a professor of political science in one of our universities proposed that the power of interpretation should be taken from the courts and be given to some executive body in supposed closer touch with the popular will, confining the courts to the task of applying the prescribed and interpreted rule. Both of these ideas, a complete legislative provision in advance covering every case, and authoritative extrajudicial interpretation, have failed in practice although they have had the advantage of careful, deliberate legislation formulated by experts and of application by bench and bar trained in the Byzantine doctrine. It is as clear as legal history can make it that interpretation apart from judicial application is impracticable, that it is futile to attempt to separate the functions of finding the law, interpreting the law and applying the law. For example, the plan of interpretation by a royal commission, tried in the Code of Frederick the Great, failed utterly. It soon appeared that there was no reason for supposing that the Executive Commission would have more foresight than the legislature. Experience quickly taught that the most which might be achieved in advance was to lay down a premise or a guiding principle and that the details of application must be the product of judicial experiment and judicial experience. Nevertheless the Byzantine doctrine dies hard. In the 19th century certainty was sought not by a complete body of rules covering every case in advance but by a complete body of principles and a complete system of logical exposition and application of those principles. All the 19th century codes in continental Europe, except the German Civil Code of 1896, go upon the theory that judicial decisions shall have no authority beyond the cases in which they are rendered and that there can be no authoritative interpretation by anyone except the legislature itself. If the codes left anything open, the judges were directed where to turn in order to decide the case. But the next judge was not to look upon the decision of his predecessor as establishing anything. He was to repeat the process independently. An excellent example may be found in Article 5 of the French Civil Code. That article reads as follows: Judges are forbidden, when giving judgment in the cases which are brought before them, to lay down general rules of conduct or decide a case by holding it was governed by a previous decision. Its purpose was, as we are told by an authoritative commentator, to prevent the judges from forming a body of case law which should govern the courts and to prevent them from correcting by judicial interpretations the mistakes made in their enacted law. Before 50 years had passed, legislation was required to compel the lower courts to follow the solemn decision of the highest court of France, and now, after a century of experience, French jurists are conceding that the article in question has failed of effect. Today elementary books from which law is taught to the French students, in the face of the code and of the received Roman tradition, do not hesitate to say that the course of judicial decision is a form of law. All over the continent the new school is clamoring for free judicial finding of law. It is agreed that the path of deliverance from the stagnation of 19th century law is a judicial empiricism, working upon the materials supplied by jurist and legislator. Anglo-American law is fortunate indeed in entering upon a new period of growth with a well-established doctrine of lawmaking by judicial decision. It is true we have to combat the political theory and the dogma of separation of powers. It is true also that the influence of these ideas and the 19th century insistence upon certainty led to a theory that the judicial finding of law was but a discovery of something which was logically or potentially pre-existing, so that the decision made nothing, it merely evidenced. Undoubtedly under the influence of this idea judicial empiricism was proceeding overcautiously at the end of the last century. Yet this was not wholly an evil. It would be most unfortunate if both legislature and court should be governed by a conception of law as will and proceed to lay down whatever seemed best, for that reason alone, unrestrained by the necessity of going upon predetermined premises or of developing them by a known technique and along fixed lines. The chief cause of the success of our common law doctrine of precedents as a form of law is that it combines certainty and power of growth as no other doctrine has been able to do. Certainty is ensured within reasonable limits in that the court proceeds by analogy of rules and doctrines in the traditional system and develops a principle for the cause before it according to a known technique. Growth is ensured in that the limits of the principle are not fixed authoritatively once for all but are discovered gradually by a process of inclusion and exclusion as cases arise which bring out its practical workings and prove how far it may be made to do justice in its actual operation. If the last century insisted overmuch upon the predetermined premises and fixed technique, it did not lose to our law the method of applying the judicial experience of the past to the judicial questions of the present and of making that experience yield principles to be developed into working and workable rules of justice by a process of judicial experimentation. There is a common element in the two fundamental doctrines of the common law, the doctrine of precedents and the doctrine of the supremacy of law. The same spirit is behind each. The doctrine of precedents means that causes are to be judged by principles reached inductively from the judicial experience of the past, not by deduction from rules established arbitrarily by the sovereign will. In other words, reason, not arbitrary will, is to be the ultimate ground of decision. The doctrine of supremacy of law is reducible to the same idea. It is a doctrine that the sovereign and all its agencies are bound to act upon principles, not according to arbitrary will, are obliged to follow reason instead of being free to follow caprice. Both represent the Germanic idea of law as a quest for the justice and truth of the Creator. The common law doctrine is one of reason applied to experience. It assumes that experience will afford the most satisfactory foundation for standards of action and principles of decision. It holds that law is not to be made arbitrarily by a fiat of the sovereign will, but is to be discovered by judicial and juristic experience of the rules and principles which in the past have accomplished or have failed to accomplish justice. Where such a doctrine obtains, not merely the interpretation and application of legal rules but in large measure the ascertainment of them must be left to the disciplined reason of the judges, and we must find in the criticism of the reported decision by bench and bar in other cases our assurance that they will be governed by reason and that the personal equation of the individual judge will be suppressed. The vitality of the common law and the steady increase in the value attributed to judicial decisions in the rest of the world attest the soundness of this expectation. We have, then, the means of progress in our law to begin with, where the rest of the world is struggling to attain it. It is the right of wisdom to preserve and develop it and to set up and maintain courts adequate to employ it instead of experimenting with the Byzantine doctrine which has been thoroughly tried and found wanting in continental Europe, or with the Byzantine method of administration in any of its forms. Much of the criticism of our Anglo-American system of judicial empiricism assumes that it is responsible for the obstinacy with which American law stood in its tracks at the end of the last century while other departments of human endeavor were moving on. But it must be remembered that American law was not alone in this respect. The world over, the law of the last century sought to stand still, and the century demanded that it do so. No matter what the form of the law, code or case law or received Roman tradition modernized and made a juristic tradition, we see the same characteristic condition of quiescence. If the causes of the backwardness of the law with respect to social problems and the unsocial attitude of the law toward questions of great import in the modern community are to be found in the traditional element of our legal system, determined by a succession of causes which I have discussed in the preceding lectures, the surest means of deliverance are to be found there also. The infusion of morals into the law through the development of equity was not an achievement of legislation, it was the work of courts. The absorption of the usages of merchants into the law was not brought about by statutes but by judicial decisions. When once the current of juristic thought and judicial decision is turned into the new course, our Anglo-American method of judicial empiricism has always proved adequate. Given new premises, our common law is the means of developing them to meet the exigencies of justice and of molding the results into a scientific system. Moreover, it has the power of acquiring new premises, as it did in the development of equity and the absorption of the law merchant. Indeed, fundamental changes have been taking place in our legal system almost unnoticed, and a shifting was in progress in our case law from the individualist justice of the 19th century, which has passed so significantly by the name of legal justice, to the social justice of today, even before the change in our legislative policy became so marked. 8 noteworthy changes in the law in the present generation, which are in the spirit of recent ethics, recent philosophy and recent political thought, will serve to make the point. First among these we may note limitations on the use of property, attempts to prevent antisocial exercise of the incidents of ownership. At this point judicial decision has been the agency of progress. This is no time or place for details. I need only refer to the gradual but steady change of front in our case law with respect to the so-called spite fence, and to the establishment in American case law of doctrines with respect to percolating water and to surface water, in which a principle of reasonable use has superseded the old and narrow idea that the owner of the surface might do as he pleased. In this growing tendency of the law to impose limitations on the use of property, especially limitations designed to prevent what the French call abusive exercise of rights, there is a suggestive parallel between the period of legal development on which we have entered and the earlier period of liberalization which I have called the stage of equity or natural law. Equity sought to prevent the unconscientious exercise of legal rights. Today we seek to prevent the antisocial exercise of them. Equity imposed moral imitations. The law of today is imposing social imitations. It is endeavoring to delimit the individual interest better with respect to social interests and to confine the legal right to the bounds of the interest so delimited. More and more the tendency is to hold that what the law should secure is satisfaction of the owner's reasonable wants with respect to the property, that is those which consist with the like wants of his neighbors and the interests of society. Second, we may note limitations upon freedom of contract. Such limitations have been imposed both through legislation and through judicial decision. As examples of legislative limitations, reference may be made to statutes requiring payment of wages in cash, statutes regulating conditions of labor, and legislation with respect to non-living wage, minimum wage and the like. As examples of judicial imitations, it is enough to remind you that our courts have taken the law of insurance practically out of the category of contract, have taken the law of surety companies practically out of the law of suretyship, and have established that the duties of public service companies are not contractual, flowing from agreement, but instead flow from the calling in which the public servant is engaged. Here again the parallel the present and the stage of equity or natural law is suggestive. Equity sought by limiting their power of contract to protect debtors against unfair advantage on the part of creditors. Accordingly it prevented clogs upon or bargainings away of the debtor's right to redeem mortgaged property and overturned oppressive contracts with heirs and reversioners. Today we seek once more, by limiting freedom of contract, to protect those who are subjected to economic pressure against unfair advantage on the part of those who have greater economic freedom. Third, we may note limitations on the power of disposing of property. These are chiefly legislative. Examples are the requirement in many states that the wife join in a conveyance of the family home, the statutes in some jurisdictions requiring the wife to join in a mortgage of household goods, the statute of Massachusetts requiring the wife to join in an assignment of the husband's wages. But there has been a tendency in judicial decision to put limitations on the jus disponendi in order to prevent acquisition or perpetuation of a monopoly by unfair underselling in particular localities. Fourth, reference may be made to limitations upon the power of the creditor or injured party to secure satisfaction. The Roman law in its classical period had developed something of this sort. In the case of certain debtors as against certain creditors, the Roman law gave the benefit or the privilege of not answering for the entire amount but for so much as the debtor could pay for the time being. Naturally this doctrine was rejected in the modern civil law as being out of accord with the individualism of the 18th and 19th centuries. The newer codes, however, have a number of provisions restricting the power of the creditor to secure satisfaction, such as, for example, provision that the statutory liability of an insane wrongdoer shall not go so far as to deprive him of means of support. In the United States the homestead exemption statutes which prevail in so many states, and the personality exemptions which in some states go so far as to exempt $500 to the head of the family, and usually make liberal exemptions of tools to the artisan, library to the professional man, animals and implements to the farmer, and wages to the head of a family, will serve as illustrations. There is a notable tendency in recent legislation and in recent discussion to insist not that the debtor keep faith in all cases even if it ruin him and his family, but that the creditor must take a risk also, either along with or even in some cases instead of the debtor. Fifth, there is a tendency to revive the idea of liability without fault not only in the form of wider responsibility for agencies employed, but in placing upon an enterprise the burden of repairing injuries, without fault of him who conducts it, which are incident to the undertaking. What D names, from the standpoint of the historical jurist reviewing the gradual development of legal doctrines based upon free action of the human will, called the unmoral standard of acting at one's peril is coming back into the law. There is a strong and growing tendency, where there is no blame on either side, to ask in view of the exigencies of social justice, who can best bear the loss. Sixth, there is a very marked tendency in judicial decision to regard the social interest in the use and conservation of natural resources, to hold, for example, that running water and wild game are, as it were, assets of society which are not capable of private appropriation or ownership except under regulations that protect the social interest. Seventh, we may note an increasing tendency to hold that public funds should respond for injuries to individuals by public agencies, that the risk of injuries to individuals inherent in the operations of government are not to be borne exclusively by the luckless individual on whom loss happens to fall. Finally, recent legislation and judicial decision have changed the old attitude of the law with respect to dependent members of the household. Courts no longer make the natural rights of parents with respect to children the chief basis of their decisions. The individual interest of parents, which used to be the one thing regarded, has come to be almost the last thing regarded as compared with the interest of the child and the interest of society. In other words, here also social interests are now chiefly regarded. It is true many of the examples I have just adduced are taken from legislation. It is true also that some of these legislative innovations upon the settled legal ideas of the past 2 centuries have been resisted bitterly by some courts. Yet I am confident that every one of them would stand in the highest court of the land and in a growing majority of our state courts today. Moreover, what is more important, many of the most significant examples are taken from judicial decisions. If, therefore, the disease is in the traditional element of our legal system, the cure is going on there under our eyes. It is an infusion of social ideas into the traditional element of our law that we must bring about, and such an infusion is going on. The right course is not to tinker with our courts and with our judicial organization in the hope of bringing about particular results in particular kinds of cases at a sacrifice of all that we have learned or ought to have learned from legal and judicial history. It is rather to provide a new set of premises, a new order of ideas in such form that the courts may use them and develop them into a modern system by judicial experience of actual causes. A body of law which will satisfy the demands of the society of today cannot be made of the ultra-individualist materials of 18th century jurisprudence and 19th century common law based thereon, no matter how judges are chosen or how often they are dismissed. For a great part the way must be prepared by juristic science and by careful legislation worked out consistently and upon a clear program, as the legislation of the reform movement in the first half of the 19th century was framed on the basis of Bentham's doctrine of utility. In reason the judges may not be asked to lead in the present transition. They must go with the main body, not with the advance guard, and with the main body only when it has attained reasonably fixed and settled conceptions. Let us remember that it is not so long ago that the votaries of the social sciences who now complain of law had succeeded in confirming lawyers in the ideas they had found in their law books. They cannot expect courts, which have the whole economic structure in their hands and are bound to regard the social interest in general security, to turn the law about in a moment. When we reflect how fundamental is the shifting from the older idea of the end of the legal order to the newer, how uncertain the new lines are as yet on the one hand, and on the other hand how completely the change goes to the root of everything the courts do, We must recognize how futile it is to expect the courts to adjust our whole legal system to it overnight. Lay bad men interpretations are superficial. The fundamental difference between the law of the 19th century and the law of the period of legal development on which we have entered is not in the least due to the dominance of sinister interests over courts or lawyers or jurists. It is not due, the legal muckraker notwithstanding, to bad men in judicial office or to intentional enemies to society in high places at the bar. It is a conflict of ideas, not of men, a clash between conceptions that have come down to us and entered into the very flesh and blood of our institutions, and modern juristic conceptions born of a new movement in all the social sciences. Study of fundamental problems, not reversion to justice without law through changes in the judicial establishment or referenda on judicial decisions, is the road to socialization of the law.